This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So this is an update in the Usherson v. Bandshell Liebowitz case. Now there are a bunch of cases with Liebowitz, so I'll remind you, this is the case where neither Liebowitz nor his client showed up to court-ordered mediation. Instead, he sent two lawyers, including his sister, who had no personal knowledge of the case. The defendant made a motion to sanction Liebowitz, and Liebowitz tried to dismiss the case, but Judge Jesse Furman was quick to say that he still wanted an evidentiary hearing to figure out what the heck was going on. If you have no idea what I'm talking about, click on the thumbnail here to watch the original video. At the hearing, Bandshell dropped a bombshell. The copyright registration in the complaint, registration number 046, wasn't the photo in question. The correct registration was number 272, which was registered more than a month after the complaint was filed. This is important because you need to complete the copyright registration process before filing a lawsuit. So now, Judge Furman has ordered Liebowitz and Usherson to submit their own declarations under penalty of perjury to explain how they ended up suing over the wrong photograph when they realized the mistake and when the court was notified. There are several declarations, so I'll just summarize. Liebowitz says that Usherson submitted a collection of photographs under the 046 registration. The photo the lawsuit was based on was taken by Usherson on the same day, at the same time, and of the same people. He submitted an exhibit that shows cropped photos from the 046 registration and the 272 photo. So you can sort of see how it happened here. This is the 046 registration on the left and the 272 registration on the right. They're the same people. Number 439 and 13 are even somewhat similarly composed, but you can see that they're very much different photographs and really couldn't be confused with one another for someone who has knowledge of the different photographs. Liebowitz seems to lay the blame on his client, who identified the allegedly infringing photo as part of the 046 registration. A lower-level employee, Zachary Cuff, was responsible for tracking the photos and registrations. Liebowitz hypothesized that Cuff missed the error because the photo looks similar to the ones in the 046 registration. Cuff seems to be the one who initiated the 272 registration. Usherson's declaration generally says the same thing. When he retained Liebowitz's law firm, he sent a CD of photos in the 046 registration to Cuff. Later, Usherson mistakenly said that Bandshell's infringement was for a photo listed in that registration. Unrelated to the Bandshell lawsuit, he sent a second CD of additional images to Liebowitz to have the copyright registered. Importantly, Usherson says this: "I did not realize that the photograph at issue in this action was not on deposit with the 046 registration, but was instead on deposit with the 272 registration until preparing this declaration in response to the court's most recent order." Perhaps because Liebowitz has been caught forging his client's signature in another case, or maybe because the court was worried about Liebowitz communicating with his client, the judge ordered that Usherson's declaration had to be signed and notarized. After the declaration is a signature page for Usherson's that's notarized. You can see how the first part of the declaration was from a file being saved as a PDF, and the second image is a scan of a printed document. So here's the printed document, and here is the scan. This is going to be important later. So Usherson seems to be taking responsibility for the mistake, and Liebowitz says a research analyst had the ability to catch the mistake but didn't. There's also a declaration from one of the other attorneys, Mr. Freeman, who was sent to replace Liebowitz during the mediation. In short, he says that he was brought into the case the night before the mediation and has no knowledge of the issue with the copyright registrations. This means that Liebowitz tried to send a lawyer that had not entered his appearance in the case, had no knowledge of it, had very little time to prepare, and had no relationship with the client. Without the client there, I don't see any way the mediation could have been productive. It's really difficult to advocate for your client when you don't know who your client is, what they want, or what the communication with opposing has been before mediation. You're in no position to represent the client, so you'll end up being useless in the meeting, which wastes everyone's time and resources. That's why Bandshell asked for their attorney's fees to be awarded as part of the sanction motion. As for the registration mistake, if the declarations of Liebowitz and Usherson are true, then it's unlikely that Liebowitz would be personally sanctioned. Lawyers work based off of what clients tell us. The remedy for the mistake would likely be to dismiss the case, which Liebowitz has already done. However, Bandshell's lawyer, Brad Newberg, isn't satisfied with Liebowitz's explanation. Let's read what he has to say. So this is Brad Newberg's letter motion to Judge Furman. I write in response to plaintiff's February 7 letter and declarations regarding the issue of false copyright registration information in the complaint in the above captioned case as per the court's January 24, 2020 order. I write again as an officer of the court despite this case having settled. To quote the court, similar to plaintiff's January 17 submission and February 7 submission, they raise more questions than they answer. Mr. Liebowitz has admitted that plaintiff filed a complaint falsely alleging that the photograph at issue was registered and was supposedly part of registration 046. While Freeman's declaration claims no knowledge of the issue at hand, the declarations of Mr. Liebowitz and Usherson place the blame for the confusion and administrative error squarely at the feet of a man named Zachary Cuff. Although Mr. Cuff was not mentioned at the initial pretrial conference when this issue was first raised, or the January 8th hearing, or the January 7th letter, or any other time, Mr. Cuff is mentioned now 30 times in the Liebowitz and Usherson declarations filed with the February 7th submission. Noticeably missing is a declaration from Mr. Cuff. That a Cuff declaration is missing is especially noteworthy given that Mr. Liebowitz makes sweeping statements in his declaration as to what Mr. Cuff probably relied upon and did, yet also states that he did not actually know what Mr. Cuff did and did not do. Upon receiving the February 7th submission, defense counsel looked up Mr. Cuff on LinkedIn but did not contact him, and it appears he may have a new job. To the extent Mr. Leibowitz's answer to why there is no Cuff declaration is that Mr. Cuff no longer works for him, A, that should not have been a bar to a declaration, and B, it seems particularly convenient to blame a former low-level employee for a sanctionable violation of the law. In any case, the Liebowitz and Usherson declarations do not make logical sense. As an initial matter, the Usherson declaration shows that Mr. Usherson merely transmitted the signature page to Mr. Liebowitz as opposed to the entire declaration. See that. In fact, unless there is a typo, the signature page does not follow precisely from the page before it, as there should be at least the word "the" between paragraph 20 lines on page 5 and paragraph 20 lines on page 6. Let's take a look. So it starts 046 registration. So it should be the 046 registration. But then it says they were in fact on deposit with 046 registration. So he suggests that unless there is a typo specifically on the word "the" in between here, these things don't quite line up. Given the history here, those two issues call the entire declaration into question. We also note that footnote 1 of Mr. Usherson's declaration mentions an October 30th email Mr. Liebowitz sent Mr. Usherson CCing Mr. Freeman about the mediation. Given the pending sanctions motion, it is remarkable that neither this email nor any other with Mr. Usherson about the mediation has been submitted as an exhibit in any of plaintiff's filings related to the motion. Mr. Liebowitz has stated that he relies on his client's truthfulness regarding copyright registrations and also that he did not personally investigate that the complaint in this case was accurate, a position he restates at paragraph 11 of his declaration. Similar claims were made at the January 8th hearing that the Liebowitz law firm does not check whether a photograph has been actually registered, but relies on its client's representations that it is so. Yet the declarations continually refer to administrative error being caused by the Liebowitz law firm's belief through Mr. Cuff's review that the 046 registration cited in the complaint contained the photograph at issue because the photograph was taken at the same music festival and contained some of the same musicians as other photographs that were part of the 046 registration. First off, the February 7th submission tries to make the photographs look similar through severe cropping, showing only the two overlapping people. Even a cursory review of the photographs at issue and the photographs in the 046 registration would show that the photograph at issue was not part of the registration. I think that's what we were trying to show here back in 2.1 in Exhibit B, that these are not the same photographs. Look at how different they look when they are not cropped. More importantly, the explanation is at odds with what the court has previously been told. Either the Liebowitz law firm reviews copyright registrations for accuracy before filing, or it does not. If it does not, as Mr. Liebowitz and Mr. Freeman represented in the past, in fact, it is a surprise to learn in these declarations that the Liebowitz law firm had the deposit copies of the 046 registration this whole time, then the idea of an administrative error made while reviewing the images makes no sense. The administrative error excuse also does not explain why the Liebowitz law firm, upon supposedly receiving a second CD of images from its client referring to the same music festival out of the blue after this case was filed, containing the actual photograph at issue, did not check to see if the complaint was accurate. This is especially true given that Mr. Liebowitz was asked about this exact issue at the initial court conference of November 14th, and Mr. Liebowitz assured the court that the 046 registration contained the photograph at issue. Either Mr. Liebowitz's representations to the court on November 14th were flat out false, or he made those assurances without knowing whether they were true and did not go back to investigate whether they were true. His declaration at paragraphs 17-18 states it was the latter. This is still inexcusable. We also note a significant gap in Mr. Usherson's declaration. Mr. Usherson states at paragraphs 15, 17, and 18, that at some time he provided the Liebowitz law firm with a second CD of images that Liebowitz registered as 272. He says nothing about the circumstances of this new registration, and not a single exhibit shows any email or communication about the new CD, photos, or registration. There is no discussion at all as to why he sent the new CD. Given the seriousness of this issue, the gap in Mr. Usherson's declaration seems purposeful. Finally, since our last submission, we have learned that this is not the only case to have these same issues. A motion for summary judgment was granted due to the photograph at question not actually being in registration as claimed, and the court awarded defendant $100,000 in attorney's fees and costs and $10,000 in additional sanctions, and noted Mr. Leibowitz's responsibility under Rule 11 to ensure his factual contentions were supported. So another Liebowitz case that was lost because it wasn't properly vetted, like Rule 11 says it should be. Due diligence is the phrase. Then there was Abbey Photography versus Advanced Publications, an order requiring Liebowitz to explain the plaintiff's assertion of facts about the authorship and registration of a photograph at issue in his litigation in the instant complaint that appeared to be irreconcilable with the corresponding allegations about the same photograph asserted by plaintiff's counsel on behalf of a different plaintiff in the Southern District of New York. And then he also claimed a typographical error which did nothing to explain why two different plaintiffs, even if related, were suing on the same photograph against different defendants in different courts. There may well be more. Unfortunately, the PACER filing system is not set up to easily reveal the machinations of an operation such as Mr. Liebowitz without significant time spent investigating each of his hundreds of cases separately. The published opinions regarding the Liebowitz law firm appear to be the tip of the iceberg. Then they cite to another case an opposition to Mr. Leibowitz's pro hoc vice motion in the Northern District of Illinois, which apparently was denied because of various violations. I think one of which was that he didn't disclose all of these other sanctions and didn't disclose that he had been disbarred from the Northern District of California for failing to properly file his pro hoc vice motions there. We therefore respectfully recommend that this court craft a sanctions decision that puts an end to or significantly alters the way the Liebowitz law firm does business in this court and others. Signed, Brad Newberg. So it looks like Brad Newberg wants more answers and doesn't think Liebowitz should be let off the hook so easily. He's even suspicious that maybe the declaration Usherson signed wasn't the one submitted to the court. If Liebowitz had edited the declaration after Usherson had signed, it would explain the missing word. Or it could just be a missing word that wasn't caught in proofreading because of the page break, like we saw in that page of the declaration here. They do appear to be the same. So maybe the word was actually dropped. But it doesn't matter what Newberg thinks, it matters what Judge Jesse Furman thinks. Judge Furman has sanctioned Liebowitz in the past, and Leibowitz's sanctions are piling up in his district and others. It's possible that the judge is willing to be skeptical of the declarations because of the history of misrepresentations in this case and the others. However, the case is already dismissed, and judges don't usually like to continue hearings for months after the case is dismissed in order to decide whether sanctions are appropriate. It's possible the judge will want to stop the investigation here, decide on the sanctions, assume the declarations are true, and move on. We'll keep you updated on the case and let you know when it's finally resolved. Let us know what you think of all of this Liebowitz shenaniganery in the comments below. So that is our show, everyone. Thank you for joining me. I am Leonard French, your favorite copyright attorney. Thank you to our sponsus.com/law supporters and our patreon.com/LJFrench supporters. This is a community supported channel, and we would not be able to produce this level of content without your help. We currently pay Brandon, Tactical is my assistant, and I pay myself out of the support that you provide and the funds that come from YouTube and Twitch. And without that, we just wouldn't be able to work at this level. And so we really appreciate whenever you make your pledge and support our channel financially. Coming up sometime here in 2020, I expect to convert this whole thing into a non-profit corporation. And when that happens, I will make a big announcement, and your contributions will be tax deductible where applicable for starters in the United States. That's not yet, but that's what we're looking forward to. So for now, thank you very much to our $50 plus supporters for the month of March: Wes Delj, Aspernari, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Blackleaf, Joe Tyson, Benjamin Hitov, Steven, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, Jared Bales, and Anders Thorenfeldt. And thank you to the $5 plus supporters who will be scrolling on the screen in front of me. These supporters will be in the description of every video that drops on YouTube. I thank you so very much. I'll bring some dogs in here. I love you all. I'm Leonard French, your favorite copyright attorney, and I'll see you in the videos. Bye. One day, you started my law practice with me. And now you just steal balls from me. Here's the grounder, the big ball. Good catch. Almost. What a nice girl. Yeah, the trees are starting to bloom, even though it's only March 5th. What a good puppy.